where his power of differentiation is affected. Now, by referring to external elements that are introduced, we want to eliminate situations where the person's brain can be affected through internal means. For instance, we know that during sleep, during intoxication too, a person's functioning of the intellect is affected, but we do not call them intoxication. Intoxication is where some external element results in affecting the brain of the person, his intellect, in such a way that he is no longer capable of differentiating vital matters. Well, now, with regard to how intoxication can affect the legal capacity of the person, in Islamic law, this depends on the fact that willful intoxication is prohibited in Sharia. A person is totally prohibited from adopting any means that can affect his intellect, because intellect is the greatest gift that Allah has given to mankind, and everything that he has to do with regard to the existence, his actions, and whatever that pertains him, all of them depend on intellect. So a person is never allowed to affect his intellect himself. So intoxication is severely prohibited. To reduce himself to the level of animals once again, willfully, is not allowed. So the rules pertaining to intoxication with regard to how it affects legal capacity are dependent on the means of intoxication. We said intoxication is where a person's intellect is affected due to introducing external elements. So how were these elements introduced into his system? In introducing these external elements that led to his intoxication, was his choice involved? Did he do that willfully? Or was it some means which was beyond his choice? So how intoxication affects his legal capacity depends on this. Meaning, was this prohibition of intoxication or self-intoxication violated when the person became intoxicated, or it happened through some means which was beyond his choice, so therefore there was no violation of Sharia? So based on this, we look at how it affects the person's legal capacity. So with regard to this, we can discuss intoxication under two headings. Where the intoxication was willful. Willful means he himself fully knowing that what he is taking is an intoxicant which can affect his intellect. With this knowledge and with his choice, without any compulsion, he took these intoxicating substances and became intoxicated. This is willful intoxication, which is a violation of the Sharia. The another type is when the intoxication was not willful. The person himself intentionally and based on his choice did not, introduce intoxicating substances into himself. It happened in a way beyond his choice, such as by mistake, or without his knowing that what he is taking is something that can intoxicate him, or by force. By force, he was made intoxicated. Or in some instances, it can also happen where some medicine is used, and this medicine can produce a state similar to intoxication in the person. So this type is referred to as lawful intoxication or permissible intoxication, which means the intoxication here is tolerated because it was not based on intentionally violating the Sharia by the intake of intoxicants. So when the intoxication is of this nature, meaning the choice of the person was not completely involved in his becoming intoxicated. Now, this form of intoxication is tolerated. Now, this form of intoxication will result in his actions and utterances not being recognized while he is in a state of intoxication, which means that he is not responsible for whatever he says or does. So his utterances are not recognized, actions are not recognized in the sense he is not does not become criminally liable for any offense that he does in this form of intoxication, because it was beyond his choice and he did not make himself intoxicated willfully and knowingly that my intellect is going to be affected. Well, so this has details. Both types of intoxication have details. We shall look at it briefly. So in this form of intoxication, when the intoxication was not willful, his actions and utterances will not be recognized, and he will not be responsible for any easy any contracts that he creates will not become valid, and no legal effects will take place, and easy any action, criminal action that he does under this form of intoxication, he will not be made criminally liable for this, because it was in a state where his intention was affected, where he did not play any role in becoming intoxicated. But looking at the second type, but remember that causing of any property loss have to be or has to be compensated, because we said earlier that property related obligations are part of the capacity of assuming obligation which never goes away. Therefore, causing of any loss or harm which can be compensated through property, that obligation remains with every person under every situation. That never goes away, neither in a child nor in an adult whose intellect is affected, because the capacity of assuming is not related to intellect at all. Well, now the second type of intoxication, impermissible, unlawful intoxication, where the person knowingly commits a violation of Sharia and knowing fully well that he is going to be intoxicated, that his intellect is going to be affected, he is going to act irrationally, where he will have no control over his sayings or actions. Knowing all this, he makes himself intoxicated. Now he remains responsible in Sharia. Remain responsible in Sharia, and his acts and utterances are recognized, because he had put himself in this state knowing that this is going to happen. So he remains responsible for whatever he does or says in the course of being intoxicated. So he remains criminally liable in Sharia. The person who, under willful intoxication, does any act that is a criminal offense, he remains criminally liable. As far as utterances are concerned, utterances are also valid, and his contracts will become valid in the state of intoxication, but subject to details. There are details about to the extent in which or to which the contracts of the intoxicated person who became intoxicated through willful means intentionally will become valid. In this, there are details. Well, so this was a brief look at how intoxication can affect the person's legal capacity. We shall go to the next factor of impediments, which is imprudence. Imprudence or suffer. We had referred to this when we discussed prudence or rushd. If you had paid attention and had got prepared and also discussed and studied from your material, because it was last week and this week we had tutorial on this on legal capacity, and unfortunately we had to cancel the tutorial on Tuesday because there was no preparation and we could not discuss. So please come prepared if you want to gain any benefit through the tutorial. Well, so now imprudence, which is saf in Arabic. The person who is imprudent is called safi. This is the opposite of rushd or prudence. By safi we mean a person who does not have good sense with regard to his property matters. A person who cannot manage his property wisely and in a rational and beneficial manner. This person is called safi. So while discussing rushd, we said rushd is an additional qualification required for property related contracts. The person, after having obtained complete capacity of execution, in order to be able to create contracts related to property in a valid manner, requires the additional qualification of rushd. So remember, having rushd or not having rushd does not affect the complete legal capacity of the person. Legal capacity remains, but if a person does not have rushd and is a safir, who has what is described as saf or imprudence, his transactional powers are affected. It is not, in fact, a situation where his capacity is removed. We can consider it that way if you only look at the transactional powers, but it is rather his transactional powers being curtailed or restricted when rushd is absent. When the person is a safi, his transactional powers are curtailed in the sense that he is not able to create transactions related to property in a valid manner. So this curtailing of transactional powers is referred to as hajr in the Sharia. We can translate hajr as interdiction. Interdiction or hajr refers to a person not being able to create property related contracts in a valid manner. The person is prevented from creating contracts or rather property related contracts in a valid manner. This is hajr. So the person who has safr, who does not have a sense of the value of property and who is prone to waste away his property if he is allowed to handle his property, is under hajr. Now, if this safr is with him when he attains complete legal capacity upon becoming an adult, despite of his obtaining legal capacity and becoming a mukallaf and becoming an addressee of the Sharia who has to fulfill its commands and avoid its prohibitions, despite of this, he is not able to create contracts and involve in transactions. So his guardian, the parent or the guardian, will continue to oversee and take care of his property and create contracts on behalf using his property. This person will not be able to create his contracts himself as long as these contracts are property related contracts. Those contracts not related to property such as marriage and other contracts, he is able to create. But property related contracts will be created by the guardian. Guardian will continue to exercise his control over his property, and the Hajar will continue on him uh, from childhood into adulthood, even after he obtains the complete capacity of execution upon becoming an adult. Now, uh, until when will this Hajar last? We said that in the Hanafi school at 25, the age of 25, irrespective of whether he becomes rushd, obtains rushd or not, irrespective of suffer going away or not, in the Hanafi school, at 25, this interdiction or Hajar will come to an end, and he will necessarily have control over his property. In the Shafi'i school especially, the Hajar will not go away until he obtains rushd. The purpose of the Hajar is to safeguard his interests as well as the interests of the parties who deal with him. If he's allowed to create contracts on his property, there is the danger that he can waste them away and become needy of others, thus becoming dependent on others, and others' rights can also be violated when they deal with such a person, because we know that this person who is under Hajar is his contracts are not valid. So there is the possibility of the rights of others being violated. Because of this, for safeguarding the rights of both parties, interdiction is in place. Well, so uh, if the state of saf occurs after he had been prudent, you see, he attained adulthood with prudence, so he obtained complete legal capacity and was a Rashid and was allowed to create contracts of property individually. And then he obtained rushd later after adulthood at some point. But after having been a Rashid or prudent person who was in control of his property, after some time he became Safi once again. Signs of suffer became apparent in him. He started to become negligent in his creation of contracts, you see, and started to waste away his property in a way that showed that he is no longer is able to he no longer possesses a sense of the value of property. So if this happens, Hajar will be reintroduced. But in reintroducing Hajar and putting in the person under interdiction in such a way that can curtail his transactional powers, this requires a court order. It is only a judge he can put him under interdiction in this way. The first type of interdiction that continues from childhood, no court order is necessary. The guardian can decide when he is prudent enough to be put in control of his property. But if it is a matter of a person becoming imprudent after having been prudent, then a court order is necessary for reintroduction of Hajar, and the court will appoint who is to be the person who shall be able to create his contracts on his behalf and become the guardian. Well, so there are details here which you should look at and obtain from your material. Well, another factor of the impediments is debt, or you may say bankruptcy. The Arabic term is iflas. Debt, dain in Arabic, or iflas, or bankruptcy. These again a vast topic. We only look at how it can affect legal capacity in a brief manner. Well, by the way, did I mention the definition of saf? Saf is defined as You see, negligence or carelessness uh, by a person wasting away his property while remaining intelligent. A sense of or state of negligence or carelessness where a person wastes away his property against the dictate of intelligence or intellect and law, against the demand of intellect and law while remaining intelligent. Why we say while remaining intelligent is to indicate that his legal capacity remains, but it only results in his losing sense of property in a wise and lawful manner, which can make him come under interdiction. Well, bankruptcy or debt. Debt refers to uh, dues to others, monetary dues that a person has to settle to others. So this can be created through multiple means. How a person can command a debt are multiple. But under iflas, we are talking about a situation where these debts or duyun or dues to others, they exceed the value of his assets. The amount that he has to settle to other people, this goes above and exceeds the value of his total assets. So at this point, he enters a state of iflas. So iflas is where his debts are more than his assets. Well, but remember, this fact alone that he has more debts to settle than the amount of assets he possesses, this does not affect his capacity or the power to transact in any way. What is material for us as an impediment can occur only when the creditors, the parties to whom he has to settle debts, they raise this issue and obtain a court order where a judge declares that such and such a person is under interdiction due to bankruptcy. This is in fact referred to as taflis in Arabic, the person being declared bankrupt. At this point, his transactional powers will be affected, which means that although his debts are considerable, less than his assets, more than his assets are less, but still his creditors are not worried because they know he's a reliable person, capable person who he managed to settle anyhow. They are not worried, so this will not affect his transactional powers in any way. But the iflas that we were talking about, which in fact is taflis, is upon being declared bankrupt through a court declaration that such and such a person has been declared bankrupt, and this will occur when the creditors raise this issue and obtain this court order. If some of the creditors raise the issue and not the others, in that case, we look at the dues to those parties who raise the issue. If the dues to them are more than his assets, in that case, he will be declared bankrupt. Well, so this has details. So once he is declared bankrupt, how will he comes under hajr or interdiction? Okay. He has complete capacity of execution, but he comes under interdiction, meaning he remains mukallaf, he is obliged to fulfill the sharia as with regard to commands and prohibitions, but still his transactional powers are curtailed. Well, in the Shafi'i school of Islamic law, once he is declared bankrupt, he may not create property related contracts because this bankruptcy is a situation where the rights of the creditors become attached to his assets. You see, in normal situations, the rights of the creditors are attached to the zimma of the person, or the, you see, the financial or monetary obligation of the person. It is a virtual obligation. You see? Meaning, in normal situation, the creditors have no right to his property as such. Here, the creditors here, their rights become attached to his assets in a state of bankruptcy. So therefore, the rights of the person to his own property is curtailed in the sense he remains the owner, but he may not create transactions because now the first consideration is to fulfill the rights of the creditors whose debts have to be settled. Well, now this has natural details. The court will handle liquidation of his assets, how it will happen. This has details. You see? So liquidation will take place you see, in a way safeguarding the best interests of the bankrupt person. You see, while you see keeping what is necessary for his necessities and his family, and at the best possible you see, rate in the proper way. It does not mean just you see, selling his assets for any offer that comes. His interest will be safeguarded. There is a whole Islamic process of how liquidation will be carried out in a way that safeguards the rights of the bankrupt person as well as the rights of others. Well, so his property related, the power of creating property related contracts will be curtailed when the person is under hajr due to bankruptcy. In the Hanafi school, he will still retain the right to create contracts relating to property. Okay? So there is no hajr per se in the Hanafi school with regard to the bankrupt person uh, because he owns the property and he can create contracts, he has intelligence, but only that those contracts which can affect the interests of the creditors, they require the permission of the creditors, such as all those contracts which are of a gratuitous nature, charitable nature, that we call contracts of tabarru, gifts, endowments, and all forms of contracts where his property is reduced. They require the approval of the creditors. In addition, those contracts which are not necessarily gratuitous, which are not tabarru'at, but they happen to be muawadat, the contracts of exchange such as sale and lease, but still they may have an element of tabarru, element of gratuity, by coming under the type of contracts called muhabat in Sharia. Muhabat are those contracts which are in fact contracts of exchange such as sale and lease, but still they have an element of gratuity because the In considering the values of what is exchanged, we see that they are partial towards the contractor. One contractor benefits more. Where can this happen? A case of, for instance, a person selling his assets at below its market value. Let's say he has a laptop, the market value of which is 3,000, but it is being sold at 1,500. So who benefits? The buyer benefits. So this contract is called a contract that has an element of muhabat, or contract of partiality, where the other part will benefit because he is gaining property wise to this contract. So in the Hanafi school, this contract too will require the approval of the creditors, because the property of the person is going down. Therefore, the possibility of reclaiming their dues is become reduced. So their approval is necessary. Apart from this, contracts that are created on par value, meaning at market value, the person still retains the right to create such contracts because his value of his assets does not erode through creating such contracts. Well, so these two has details. So please go through material with understanding and obtain information with regard to these impediments. So we shall discuss death, sickness, or terminal illness, maradul maut, in our Monday class, inshallah, and then go to discuss the second element, or the part of legal contractors, pertaining to contractors, that we refer to as legal authority. Well, so you had submitted some topics for assignment, which were not good at all. Most of them were just, some of you seem to have searched the internet and submitted the topic of the first paper that you came across. It cannot happen that way. So think of a topic which is related to something in the course outline, but not straight away from the course outline, where you have to do some work and research. So think well. This is why I said you should submit by the 3rd week, so that we can, by the end of 5th week, complete and finalize the topics. Did not happen. So within the next few days, before the end of this week, you should finalize the topics so that you can start work on your assignments immediately. Well, so thank you very much for your participation, and please come to the